Hi everyone, it's your friendly neighborhood lawyer here. Today I want to give you guys an important analysis on the eligibility requirements for the Canada Recovery Benefit, the CRB, and specifically I want to talk about this kind of confusing and ambiguous part from the eligibility criteria, which says you have not turned down reasonable work during the 2-week period you're applying for. Now, why is this important? Well, since the CRB is going to be active until September 2021, and these days, given the uncertainty, we don't all know what our job or work situation will be like in the near future. You might not be working right now, but what if a job opportunity comes up and maybe you don't want to take it? You want to wait for something better. Are you forced to take it? And can you still receive the CRB? So to answer that, it all depends on what's reasonable in the situation. And what this word reasonable means in the context of the CRB is what I'm going to explore today. As always, this is not legal advice. This is simply legal information and my own opinion about it. You can retain a lawyer if you need specific advice for your situation. So, if we want to know what our obligations are regarding the CRB, we need to go to the source of its authority, which is Bill C-4. We go to the Royal Assent version, which is the version that is now officially a law in Canada. This law is called the Canada Recovery Benefits Act. Part 1, Section 3 tells us the eligibility requirements of the CRB. Specifically, we are going to look at subsections K and L, which both tell us 3 things that could disqualify you from receiving the CRB for any 2-week period. And this is because the CRB is administered and paid out on the basis of 2-week periods, as opposed to the CERB, which was a monthly benefit. So here are these 3 factors, and for all 3 of these, as subsection I says, you must be looking for a job or self-employment during the 2-week period you want to receive the CRB. A. If you had a job and stopped working due to COVID, then your employer requests you to come back and it's reasonable for you to come back, and then you don't go, then you would be disqualified. B. If you were self-employed, you stopped due to COVID, and then it's reasonable for you to go back to your self-employment, but you don't, then you would also be disqualified. And C. You are unemployed and then you're given a job offer that is reasonable and you refuse to take it, then you would also be disqualified. So what we see is that this idea of what's reasonable is hugely important. What would be reasonable for you to go back to your job or your self-employment that you were laid off from or stopped working at? What is a reasonable job offer? Now, unfortunately, despite being such an important word, reasonable is not defined in this statute. So usually in tax-related matters, when some important word or concept is not defined in the law, what will happen is the CRA, the Canada Revenue Agency, will put out their interpretation of it. And their interpretation is essentially communicating to the taxpayers, this is how we are going to treat it when you deal with us. Now, one important caveat here is that it's well established in Canada that the CRA's interpretation of tax laws are not binding laws, because the CRA is just an administrative agency, they are not the legislature or the judiciary. However, because they have the experience and specialty in dealing with tax matters, their interpretations will definitely at least be considered by a court if you ever end up in a tax court in a dispute with the CRA. So anyway, let's go to the CRA's interpretation of what reasonable means for the CRB. So first of all, they say that everyone is different, which means that what might be reasonable for one person in one circumstance might not be reasonable for someone else in another circumstance. Here's the important part. It says that the main purpose of subsections K and L of the eligibility part of the law is to get people back to work as soon as possible. So that leans towards it being a much more strict standard of whatever employment opportunity you get, you have to take. But it softens that harsh stance by saying that you are allowed to exercise sound judgment regarding your personal safety and your family's and how the work opportunity responds to your circumstances. So basically we're looking at 2 things if accepting a job or going back to work is going to be reasonable or not. One is safety, is it going to be safe for you and your family? And 2, does the new opportunity match what your original or regular type of work was? So the CRA here gives a couple examples to make things more clear. So here's one question. If I was working full-time but can now only find part-time employment at a lower salary, does that constitute when reasonable? Do I have to accept the job? It says that if you're given a part-time job back with your old employer at a similar pay, you have to accept it because you would probably be given more hours in the future. And if you are receiving less than half of what you used to make from your original position, then you are still eligible to receive the CRB while of course working that part-time job. On the other hand, if a part-time job that you are offered is not related to your skill set and offers a much lower salary, then you could reasonably refuse it. It also says that if your employer promises to hire you back when they can, you can't just hope for that to happen and collect CRB in the meantime and not look for work. You have to look for work and take another reasonable job offer if you are given one. The exception is that your employer gives you a specific return date for when you will come back to work, and that date is in the next couple of weeks of the CRB application period. And that next couple of weeks part is important, because if your employer says we will hire you back exactly in 6 months, again, you can't just stop looking for work and collect CRB for the next 6 months. You would have to look for work and accept reasonable jobs, and in that situation, a reasonable job would be something that is for a period of time that is less than 6 months so that you can return to your original job. Now, aside from the CRA's interpretation of what reasonable means, we can also look to other laws that are related to see if they shed any light. One law is the Employment Insurance Act, the law that sets out the EI program. And the reason why that law might be helpful here is because it has a very similar purpose to the CRB, which is to provide payment as assistance to people who have become unemployed, but to also compel these people to try and return back to work. In the EI Act, it's not called reasonable work. Instead, it's called suitable employment. If you don't seek and accept suitable employment, you are disqualified from the EI program. But in the EI Act regulations, it does provide us with criteria of what would make something suitable employment. One is the person's health and physical capabilities to commute to the job and do the work. Another is the hours of work being compatible with family obligations and religious beliefs. Another is the type of work being compatible with the moral and religious beliefs of the person. These criteria that determine suitable employment for receiving AI should presumably also determine whether a job offer is reasonable for the CRB. So, to put it all together, what does this mean for you for any 2-week period when you're applying for the CRB and you're offered a job or you have a chance to go back to your old job or to return to self-employment? How should you consider it? Well, the first part is the health and safety part. Is the job safe for you and your family? If you have safety concerns about the job related to COVID, the CRA says you have to talk to your employer about those concerns, and you can go further and talk to the health and safety representatives or the committee at that organization, or you can talk to the Department of Labor in your province and even the Canadian Centre for Occupational Health and Safety. My sense is that as long as your employer is following the government-mandated guidelines and protocols related to COVID for whatever the industry is or the type of workplace that they are in, then you can't claim that it's unsafe, whether you feel that it is or not, unfortunately. But you can use those resources to make sure that the employer is not missing any of those policies that they need to be following. Aside from COVID, other health and safety issues could make it unreasonable work which you could reject. And your own health and physical capacity to commute there and do that sort of job could also potentially make it an unreasonable job depending on the situation. You could also potentially reject a job offer because of your religious or moral convictions based on the type of work, or religious or family obligations for the hours of the job. So for example, if you're required to work afternoons, but you have to pick up your child in the afternoons, then it's not a reasonable job for you. What's important about these other issues, if you want to use them to claim that a job is not reasonable for you, is that they have to be consistent with your past employment as well. So it's going to be difficult for you to reject a job because you're claiming that it's too physically demanding or that it's against your moral beliefs, but you were doing the same type of work right before the pandemic. So you just want to keep that in mind. The second part of seeing whether a job is reasonable for you during any CRB period is how well it fits with your prior job and work history. One thing that's mentioned in the context of suitable employment for EI is this idea that it's not necessary for the job to be in the exact same occupation as you were doing before, but rather overlapping with your skill set, the type of duties you've done, the education, training, and qualifications you have. So for the CRB, the point is that you can't say that because a job doesn't have the same title or is a different position from your past jobs that it's not reasonable, because if it largely overlaps with the fundamentals of your past work, it still is reasonable. And in terms of pay, so your wage and salary, again, you're going to have to look at your work history and use that to reject reasonable offers. If a job is significantly below the pay you are used to for the type of work you do, then it's not reasonable for you to accept. But in terms of the hours or structure, so full-time versus part-time or contract versus permanent, here it's much more strict than just relying on your previous work history. As I said previously, the CRB law, just like EI, wants to get people back to work as soon as possible. And so you may be forced to settle for less hours and shorter work periods, but you can still claim the CRB by having a 50% reduction in your income, assuming that you meet its other criteria. On the other hand, there could be scenarios where taking part-time work would force you into a financial position where you can't even pay your bills, and so you may need to find full-time employment as the only reasonable work that you do. Again, it all depends on the circumstances of your situation, but what I've outlined here are the factors that you can use to weigh and justify your decision making. So that about sums up our look into what reasonable means in the context of the CRB. I'm sure more information will come out of the CRA about different scenarios and the CRA's response to what reasonable means in those circumstances as we progress and they receive more questions from taxpayers that they want to communicate publicly. I hope you found this video useful, and please let me know if there's any other aspect of the CRB you would be interested in hearing more about, and please like the video and subscribe for more.